Greetings. Today's lesson is designed to introduce you to the area of legal practice known as civil litigation. In this lesson, we'll be covering such topics as the nature of civil litigation, the differences between procedural and substantive law, and the role and responsibilities of the litigation paralegal. So what is litigation? Litigation is the process of resolving private disputes through the court system. Unless the parties are able to resolve their dispute, the litigation process usually results in a trial or hearing, where the parties present their evidence to a judge or jury. The judge or jury then decides the dispute. Before this happens, a great deal of investigation, research, and preparation takes place. The law of civil litigation consists of both procedural law and substantive law. Procedural law is the method we use to enforce our rights. Substantive law is the area of law that creates, defines, and explains our rights. For example, procedural law answers questions such as these. What court should an action be filed in? What type of documents should be filed? What are the technical requirements for documents filed in court? How must the defendant be notified of the lawsuit? What are the time requirements for the various procedures? Categories of civil substantive law include the following: contract law, tort law, real estate and employment law, intellectual property, wills and trusts, partnership and corporate law. Categories of criminal substantive law include murder, assault, and battery. Now let's go over some litigation vocabulary terms. The person bringing a lawsuit is known as the plaintiff. The defendant is the person being sued. Most often, the parties have hired lawyers to represent them. Pleadings and other court documents are prepared by the parties' attorneys. The process of civil litigation formally begins when the plaintiff files a written document called the complaint. In the complaint, the plaintiff alleges or claims that the parties who are being sued, also known as the defendants, have done something or have failed to do something which entitles the plaintiff to relief. After the complaint is filed, the defendant is served with a copy of the complaint and is given the opportunity to contest the lawsuit by filing a document called an answer. In the answer, the defendant states why the plaintiff is not entitled to any relief. At this point, the defendant has the option of doing nothing and ignoring the complaint. If this is done, the defendant is said to be in default. In most cases, the plaintiff then obtains a judgment of an award of money damages or other types of relief. Now let's talk about the role of the litigation paralegal. A paralegal plays an important role in a litigation law firm, although that role often varies depending on the specialization and size of the law firm. Some of the duties of a paralegal include administrative duties, such as maintaining the firm's calendaring system, organizing client files, and assisting with computerization of litigation. Pre-litigation facts investigation, which includes interviewing clients, obtaining statements from witnesses, gathering evidence, such as police reports, photographs, and researching factual and legal issues. With respect to commencing litigation, some of the paralegal's duties include researching substantive law of the case, drafting pleadings, coordinating service of process, drafting motions, orders, and memoranda. Paralegals also assist in the discovery process, which includes duties such as drafting written forms of discovery, analyzing and coding documents for document production, preparing clients for depositions, setting up, reviewing, and summarizing depositions, and reviewing discovery obtained from opposing parties. During trial, paralegals are involved in organizing files and evidence for trial, serving witnesses with subpoenas, preparing the client to testify, drafting jury instructions, organizing trial exhibits, coordinating technology needs with the court, and assisting the attorney with anything the attorney needs during trial. Finally, the paralegal also assists with post-trial work in filing notices of appeal and obtaining the record on appeal to assist the trial lawyer in preparing the appellate brief to be filed with the court. Obviously, as a paralegal, you will perform many tasks in the course of a lawsuit and play an important role in the litigation law firm. However, the litigation paralegal is not an attorney and therefore cannot practice law. In a litigation law firm, some important functions cannot be performed by the paralegal. With very limited exceptions, the paralegal cannot appear in court, cannot ask questions at a deposition, and cannot give legal advice to a client. These and other ethical concerns will be covered in future classes. Thank you, and please email me if you have any questions.